The bill arrived and it had numbers on it that did not match what anyone explained before your loved one was admitted. Maybe you paid it because you did not know there was another option. Maybe you are looking at it right now in the same stack of paperwork that has been building since the admission, and something about it does not sit right. That moment, the one where the numbers do not add up and no one is offering to walk you through why, is exactly the moment this channel exists for. Here is what most families never find out until after they have already paid. Medicare Part A covers a defined set of services during a qualifying skilled nursing facility stay, and within that covered period, facilities are legally prohibited from charging families separately for those services. The list of what is included is longer than almost any admissions coordinator will volunteer, and the practice of billing families separately for covered services is documented in federal enforcement actions, inspector general reports, and whistleblower lawsuits filed in federal courts across multiple states. By the end of this video, you will know exactly which 6 categories of charges you are legally protected from paying out of pocket during a covered Medicare stay, and the specific federal complaint mechanism that recovers wrongful charges in fewer than 90 days in most documented cases. The first category is routine nursing care and medication administration. Under Medicare Part A, a qualifying nursing home stay covers all nursing services required by the resident's plan of care, including medication administration, wound care, and routine hands-on nursing tasks. Facilities sometimes present these as a supplemental care package available for an additional monthly fee. The Office of Inspector General of the Department of Health and Human Services, headquartered in Washington, D.C., named anti-supplementation as an explicit compliance risk area in its November 2024 Industry-Specific Compliance Program Guidance for nursing facilities, stating directly that facilities must accept Medicare payment as payment in full for covered services and may not charge enrollees or their families any additional amount. The guidance named the pattern. Facilities have been operating it for years. A supplemental nursing care package priced at $800 to $1,500 per month, billed during a 12-week Medicare covered stay, represents between $2,400 and $4,500 charged for services the federal government was already paying. That is not a billing error. That is a revenue line. The second category is physical, occupational, and speech therapy when ordered by the attending physician as part of the plan of care. Medicare Part A explicitly covers medically necessary therapy during a qualifying skilled nursing admission. Facilities sometimes present therapy upgrades or specialized modalities as elective services requiring separate payment. When the therapy is physician ordered and documented in the plan of care, coverage is not a matter of what the facility chooses to offer. Kindred Healthcare, headquartered in Louisville, Kentucky, agreed to pay $125 million in 2016 to resolve federal allegations that its skilled nursing facilities billed Medicare for medically unnecessary therapy while withholding covered services from residents whose families did not separately pay for them. The qui tam complaint was filed in federal court in the District of Massachusetts. The settlement documented the pattern. The pattern did not end with the settlement. The third category is nutritional supplements when prescribed as part of the medical treatment plan. Standard supplements ordered by a physician to address documented malnutrition or post-surgical recovery needs are covered under Part A during a qualifying stay. Families are routinely asked to purchase these separately from the facility pharmacy or an affiliated vendor. The supplement the family bought for $42 in the gift shop was already covered. Nobody said that out loud. That is not a coincidence. That is a business model. The gap between what Medicare covers and what the billing team presents on admission day is a structural feature of a billing environment where most families are operating in acute stress with no baseline for what they should be paying. If you are finding this useful, this is what this channel does. Every video covers something the senior living and elder care industry would prefer your family never found out. Subscribing means the next investigation reaches you before you need it rather than after. Going through Centers for Medicare and Medicaid Services enforcement records alongside the OIG's published compliance guidance for skilled nursing facilities, one pattern becomes impossible to ignore. The part of this that most families miss is not the individual charge, it is the timing. The billing practices that generate the most recoverable wrongful charges are presented to families in the first 72 hours of admission, before anyone has had a chance to understand what the Medicare coverage period includes or how to contest a charge that should not exist. The billing team knows exactly what the family does not know yet. The admission paperwork is designed around that knowledge gap. The fourth category is medical transportation to appointments directly related to the condition that triggered the skilled nursing admission, when physician ordered. Facilities bill separately for medical transport at rates that can reach several $100s per round trip. Over a 90-day stay with recurring appointments, that exposure compounds quickly for a service already covered. The fifth category is incontinence supplies, pressure relief equipment, and wound care materials required by the plan of care. Medicare Part A coverage during a qualified skilled nursing stay includes the supplies necessary to carry out the prescribed care plan. Families are routinely asked to bring their own supplies or purchase them through the facility. The itemized supply charges on nursing home bills frequently include products that are legally required to be covered. The sixth category is any charge appearing on an itemized bill for a plan of care service that was not disclosed in writing as a non-covered elective service before it was incurred. The requirement that facilities distinguish covered services from genuinely elective non-covered services in writing in advance is codified in CMS Admission Agreement Disclosure Requirements. A facility that charges for a plan of care service without prior written non-coverage disclosure has not provided a legally compliant bill. That is the foundation of the recovery process. Everything before this point is what facilities count on families never putting together while they are focused on the care their loved one needs. What follows is the specific process for recovering wrongful charges, and it is faster than most families assume. First, request an itemized bill in writing. Every Medicare beneficiary has the legal right to one. The facility is required to provide it. Cost? None. What it prevents? Paying a summary bill that obscures line items covered under your existing federal benefits. Second, compare each line item against the plan of care, which you also have the right to request in writing. Any plan of care service appearing as a separate charge is a candidate for formal complaint. Time required, 30 minutes. Cost? None. Third, contact your state health insurance assistance program known as SHIP. SHIP counselors in every state are federally funded, free to use, and trained specifically to identify wrongful billing during Medicare-covered stays. The program is administered through the Administration for Community Living in Washington, D.C. Time required, 1 call or online intake. Cost, none. What it recovers: confirmed wrongful charges with a formal complaint record attached to the facility's compliance history. Fourth, if the confirmed violation involves Medicare funds, consult an elder law attorney about False Claims Act qui tam provisions. The Kindred settlement was initiated by individuals who knew this mechanism existed. Most families do not. When the government intervenes in a qui tam action, the False Claims Act sets the relator's share at between 15 and 25% of the recovery. When the government does not intervene and the relator carries the case, that share rises to between 25 and 30%. Most elder law attorneys assess these matters at no upfront cost. Fifth, document every verbal assurance and every charge that appeared without prior written non-coverage disclosure from the first day of admission. 15 minutes per billing month. That documentation is the evidentiary foundation of any recovery. Sixth, look up the facility's corporate parent through the Nursing Home Care Compare ownership database, which the Centers for Medicare and Medicaid Services maintains as a public record. Corporate ownership determines which entity a formal complaint names. 10 minutes, free. The total time investment is under 90 minutes. The average wrongful billing exposure during a 90-day Medicare-covered stay, based on OIG documented pattern findings, runs between $4,000 and $12,000 in charges that should never have reached the family. 90 minutes against $12,000 is not a difficult calculation. Before this video, you were someone a nursing home billing department was designed to move through an admission process and a monthly invoice cycle with no framework for knowing what those invoices were legally required to include. You had no reason to know that the OIG's compliance guidance for nursing facilities explicitly names anti-supplementation as a risk area and states that Medicare payment must be accepted as payment in full, that SHIP counselors exist in every state and are free to use, or that False Claims Act qui tam provisions exist because Congress decided the people most likely to find Medicare billing fraud are the families absorbing it. The bill on your table is not necessarily the bill you owe. That distinction now belongs to you. If your family has dealt with this specific situation, share what happened in the comments, because understanding how widespread this actually is matters. Share this with anyone in your family who is dealing with any of this. And if you want to stay ahead of the industry rather than behind it, subscribe. The next one is something most families find out too late.